A Guide to Forensic Audit Report Part 5. Some of the essential clauses of engagement letter. 1. Scope of work involved and agreed by the management. This clause defines the work to be done and identifies the client. The role of the management is also described in this clause. This clause also explains the objectives and parameters to be considered, the context within which the engagement is to be conducted, whether the scope can be expanded as the work progresses or not. The clause provides the management's responsibility to make all financial records and related information available to the accountant auditor in a timely manner. 2. Indemnity clause. Indemnity clause defines and assigns the risk of carrying out transactions between two parties by obligating one party to bear the expenses incurred by the other party under certain circumstances. The scope of the indemnity clause depends on the nature of engagement and the local state governing laws that apply. One should be careful while adding an indemnity clause and must include a clear dispute resolution provision. It is on occasion when the parties disagree over an indemnity claim that the clear dispute resolution provision will come into play. However, limits on the liability are important. Much deliberation has to put to whether to exclude indemnity obligations from a disclaimer of consequential damages. 3. Non-disclosure by client of the advice report. An auditor's paperwork and the various documentation carried out in the process of audit are the property of the auditor. To avoid future conflict with the client, there should be a clear non-disclosure clause by client of the advice report detailing that the client promises to not make any disclosure of any of the pertinent fact and make every diligent effort to maintain confidentiality. Moreover, apart from maintaining confidentiality, it should also document the client's promise to immediately advise the auditor if it becomes aware of any inaccuracy in its record keeping or dishonesty in any of its business dealings. 4. Dispute resolution provisions. There should be a dispute resolution clause allowing the parties to decide upon mechanism procedure for the resolving the dispute before the dispute actually arises. Alternative dispute resolution procedures like arbitration, negotiation, mediation may be beneficial for timely resolving the disputes between parties and reducing litigation costs. These are alternative methods for having a dispute decided outside the formal courtroom setting. 5. Termination/expiration of the engagement. Every engagement letter should elaborate the circumstances in which each party may terminate or withdraw from the engagement. This clause should explain that circumstances may arise which prevent completion of the engagement or may require the auditor to withdraw from the engagement. It is always beneficial to use broad language allowing both the client and the auditor to terminate the engagement at any time and for any reason subject to any rules and regulations of professional conduct that may apply to the auditor. In the next video we will discuss about drafting a forensic audit report. So keep watching.